The 6th District Court of Appeal. As the marshal said, I'm Dan Traver and I'll be presiding today. I'd like to introduce you to the rest of the panel. To my left, your right is the Honorable Mary Nardella, and to my right, your left is the Honorable Petra Brownlee. We have one case on the docket today. It's case number 23-2448, Sierra Properties Limited, doing business as Caribe Royale Resort Suites versus Melissa Allen. Before we get started, understand that this is being streamed live on YouTube. If anybody has their cell phones on, we'd really be grateful if you put them on, if you silence them. Counsel, typically 5 minutes for rebuttal. Would you like more or less?
5 minutes will be fine. Thank you, Your Honor.
All right, whenever you're ready, sir.
Thank you. Good afternoon. May it please the court, Jack Ryder on behalf of Caribe Royale. Your Honors, we believe this case gives this court a perfect opportunity to delve into what I believe has not yet been considered in this district, and that is what is the standard and duty of care that is afforded by a property owner to an invitee or a licensee on property when you've got a landscaped area that is not designed for pedestrian traffic, not intended to be stepped on or walked on. And I submit that this court should align itself with those districts which have examined circumstances that have facts that are virtually identical to the facts that were presented in this case, that demonstrate that as a matter of law, Caribe Royale should not have been held accountable for the injury that resulted here to the plaintiff. I'm sorry, were you gonna? Oh, I thought you were gonna ask a question.
Oh, I have lots of questions, counsel. Okay, so let me start with your initial brief. Is your initial brief asked us to re-examine Grimes in any way, or do you not take any, do you not have any criticism of that decision?
I think Grimes is completely distinguishable on its facts.
Right, I understand it, and that seems to be your position in the brief. Would you say that there is a common law basis for finding a well-trod or well-worn path exception to the landscaping? So, right, you have a duty of care to business invitees, right?
Yes.
So then we go, well, there's an exception for landscaping, right? Because it's not dangerous as a matter of law.
Exactly.
And then there seem to be some cases that have said, well, if a path is well trod, we're going to eat into that rule. Where do you stand on that?
I'll start from the premise of I don't believe that there's any common law basis for that exception. So I would start from the premise of I don't think, with respect to the third district, that Grimes is correct. But I don't think that this court necessarily has to discount the logic of Grimes only because the facts are so distinguishable. So I will answer the question in two ways. Where do I stand on it? Number one is I do not think common law recognizes the exception that the third district kind of articulated, and some other courts have sort of alluded to, that the idea that if there is a landscaped area, but it has over the course of time become an ongoing, continuous, well-worn path, that somehow elevates the standard of care or takes that open and obvious, not dangerous as a matter of law situation and turn it into something else. So I start from that premise. But again, as I mentioned, what's interesting about Grimes, what makes it so distinguishable from the multitude of other cases that we've cited, which I'll go through, and distinct from this case, is that in Grimes, not only was there clear testimony that the path had become utilized and it was known to be a continuous ongoing use path, there was abundant evidence of that to the point where the owner of the property had even put a garbage can at the entryway.
Right, so in that case, there's some acceptance of the path, right? So it's not just evidence that there was notice, we veered into acceptance for Grimes of the path.
It's acceptance.
But when it comes to notice, is constructive notice enough? Is actual notice enough? Or does there have to be acceptance if we were to adopt some well-worn path exception?
If this court were to go the route of going with a well-worn path exception to this principle, then I would submit that it has to not simply be notice. Notice is not enough. When I say notice, for example, the fact, and again, multiple courts kind of delve into it in this way, the fact that people know that an area has been utilized by pedestrians that's not designed for pedestrians, the fact that there's an awareness that it has been used, notice, is not tantamount to acquiescence or acceptance. And it's the acquiescence or acceptance that I think Grimes really looks to in kind of articulating that exception. It's not simply we knew that people were using it. We knew and we accepted. in
How do
that
you
case.
square that? Oh, sorry. Go ahead, Judge
No,
Brown.
go ahead, Judge Nardella.
How do you, and tell me how you frame that when we have a general duty principle that looks at sort of like foreseeability, which kind of goes to the notice principle in this? Where
Sure.
does that fit?
Because foreseeability is distinct in this context, because the landowner's duties are, one, to warn of those dangers that are reasonably known or knowable and not known to the invitee, and to make the property reasonably safe to the extent that they can. So the idea of foreseeability, or the notion that there's an area that could be dangerous, doesn't really factor into that in this equation, I would say. Because again, knowing that an area could potentially pose a risk if utilized, a landscape area, an area of rocks or rubble, an area, in other words, open and obvious. So it might be foreseeable that if a person were to traverse an area that was not intended for pedestrian traffic, it could result in injury. But that's why the cases say that if it is so open and obvious, like a landscaped area, and it is intended not for pedestrian traffic, but for whether it's beautification or a space separator, whether it's foreseeable that a person might take matters into their own hands and dangerously traverse an area that's not intended for pedestrian traffic, it might be foreseeable, but that doesn't elevate the duty. That doesn't transform into a duty of care that's different than the principles that are espoused when it comes to a property owner's general duties, one, to warn, or two, to protect, or to make the property reasonably safe. The fact that it's foreseeable that something could happen, I don't believe factors into that equation. And especially in light of the abundant precedent, well, of course, not precedential in the sense that it doesn't bind this court, but very informative and persuasive in the fact that these multitude of cases have gone through this very same analysis, and they say over and over again, if it is a landscaped area, it is not designed for pedestrian traffic, it is open and obvious, and it is not inherently dangerous as a matter of law. So there's no duty to make it reasonably safe.
But we have some case law, we have it at least in Grimes, and we have other cases distinguishing Grimes. So they're at least acknowledging that, right? And not
Yes.
saying we disagree, we depart from that. So if we have that case law saying, well, once I've got this well-trod path and presumably they're on notice, I think it says less about acceptance, right? I think that's, I'm not sure that that's borne out in Grimes, but if Grimes is talking about notice, what are we to do with testimony that we have in this case, at least identifying the area where she walked over as being what the grass is dead? I mean, there's some testimony about that. So do we have to disregard Grimes to rule in your favor?
You don't have to disregard it. You can distinguish it. And I think that's very significant in terms of the distinction. And here's why. Let me talk about Grimes. Grimes, it wasn't just that there was evidence that others had utilized the path. In Grimes, the court actually says that it had been transformed from a grassy area to like a dirt path. So it wasn't simply that there was evidence that people had walked on it. There was evidence that people continuously and in an ongoing walked on it, that it was a continuous use. So it was on notice. So the landowner was on notice of that continuous use. That's number one. Number two, I think it's very important that somebody in Grimes put a garbage can at the entryway of the path. Because what does that tell us? That tells us that it wasn't just that they were on notice. They acquiesced, they accepted.
But is that acquiescence part of the test that we're to look at set forth in Grimes, or does it have to do with instead being on notice that the pedestrians are perhaps wrongly, but they're using this path?
I think that it is a combination of both. I think it needs to be more than just notice. And here's why. I looked at the case law.
Yeah.
The Pio case, one of the most recent cases at the second district. In Pio, you had a person who walked into a landscaped area, and I want to highlight this. They noted that it ran along a sidewalk, which we have here. Grimes doesn't talk about an abutting or adjacent sidewalk that would have been a separate pathway. In Pio, just like in this case, we have a sidewalk that was available to the pedestrian. In Pio, the court affirmed, and the court talked about the fact there's no duty to warn or to make the property safe. Noted that there was no need for the shortcut path because the landscaped area was surrounded by a parking lot and sidewalk. And here's the part that's critical. In Pio, the court said it was foreseeable that people would step into the grassy area based on the security guard's deposition testimony that people on occasion had stepped through the grass to reach the sidewalk to access the mall.
Could a
So-
reasonable jury have decided that this wasn't a landscaping area? And I asked that question thinking that we can distinguish the fact patterns in all of these other cases with this one by the nature that in this particular case, so for example, PO, the landscape area consists of grass, trees, mulch, shrubs, and landscape lighting near the grass bed where PO was injured. This, how is this that? This looks like, and granted, neither of the trial lawyers in this case introduced an untrammeled view of what happened. We have that in the deposition, but we don't have that in the trial record. The jury didn't see that. So, but what we have is a row of cars butting up against each other. And the way that I look at it is you step over the curb, there's no mulch, there's no shrubs, there's no landscape lighting, there's no features. You take one step and then you go off the other curb. Could a reasonable jury have decided that this wasn't a landscaping feature?
No, Your Honor. No, I don't think so. And I'll say why. First of all, I have seen the pictures. They are on the record. I think it's a record at 463. There's a series of photos. Number one,
That's AL marked for identification plaintiffs.
I
The
don't
one with the,
recall.
the one
I
with the
don't.
little pink car
Yes,
blocking where
yes,
she
it's
walked
not,
through.
it's not the best photo.
Right.
It's not. I acknowledge that, but there are some photos that, number one. Number two, nobody disputed, I do not believe, that this was a landscape area. They simply said that they had seen at least indicia of others having had walked on it. They didn't come in and say, well, that's a footpath or that's not a landscape area. So I don't even think that's a disputed issue. I think that they simply said, sure, it was a landscape area. And the fact that there was a sidewalk right next to it didn't mean they couldn't walk over that. Again, I look at PO for this. In PO, there was no evidence that the grass bed had become a well-trampled footpath or that the grass bed had been in continuous and obvious use as a pedestrian shortcut such that the mall was on constructive notice of the condition. There was only evidence that a few people had walked from their vehicle across the grass to the sidewalk on occasion. This was not sufficient to create a duty.
So then what is, so number one, I would note, I don't see this acquiescence piece that I think you want us to, I don't know, latch on to or really use to distinguish Grimes. So I'll just note that based on what you just said, which is what you just read is my understanding of the law as well. But there's clearly in that case, few people, right? So they're acknowledging some people have used this wrongly as a footpath. So how many people, so when does it become enough? I mean, candidly, the pictures in this case, this isn't like a beautiful median with well taken care of grass. It's Florida. I'll grant you that's hard. You know, I don't think it's a situation where we can tell one way or another how many people have gone through there. So where do we draw that line?
Well, the answer to that question in this case comes from the evidence presented. And the only evidence we had in this case came from, well, I'll say this, the evidence I'll point to first comes from Anderson, which was our witness, who said that she had awareness that others have walked across it, that it had happened.
Mhm.
She did not say this was a continuous ongoing use of a path, that this was a known issue, that people do this all the time. You won't find any testimony in this record that this was an ongoing use. You will find testimony that people have in fact traversed this area. Now, the plaintiff did say that they perceived it to be a path. They perceived it to be worn down, but it's not described, again, as.
So let's talk about that.
Sure.
I agree with what you said. There's no description. The only description, factual description we get to support a finding that this was a well-worn path is that there was no grass. There was dead grass, right? At what point is this a judge question? At what point is this a jury question to get to the well-worn path? And it goes to Judge Brownlee's point of first, you know, you're setting the standard to be continuous, and I get that. That doesn't have to be a numerical standard, but there has to be some evidence of a continuous use. But the second is who gets to decide? We have, as I see it, the testimony that you talked about from your security guard. We have testimony from the plaintiff and the plaintiff's daughter. The plaintiff's daughter appears to me to be testifying based upon her view of a photo. And the plaintiff herself just says boldly, it's well worn. Is that an evidentiary basis to go to the jury, or is that a conclusory statement, or is it both?
Well, first of all, it's certainly a conclusory statement, number one, in terms of whether or not that's sufficient. I don't believe that based on the case law, that one person's statement that I looked at a path and it was well worn to the pedestrian is sufficient. It has to be the landowner. I mean, if we're going back to the concept of notice, even if we don't, even Judge Brownlee, if we don't look at it as acquiescence, if we're talking about notice, okay, the distinction, the fact that the plaintiff perceives something and then says, well, it looked like a well-worn path to me. That's not notice to the landowner who says, I've seen people traverse it, but there's a sidewalk right next to it. That's why we have a sidewalk, because it's not intended for foot traffic. And
Could that be
Yes.
constructive notice though? And if it could be constructive notice, would that be enough?
that would not be enough.
You have to have actual notice.
No, I'm not saying that.
Okay.
What I'm saying is that the fact that you know that people have traversed this area is not sufficient notice to suggest that you now have an elevated duty of care. Because, I mean, unfortunately, people often will walk on areas that they're not supposed to. And the law recognizes that. The law says they shouldn't. But if they do, that doesn't elevate the landowner's duty of care to that person. And in terms of, is it a question of fact or a question of law? We cited True Green versus La Parra, Dampier versus Morgan Tire, Taylor versus Universal, Wolf versus Sam's East, obviously other courts, the second, the fourth, and the fifth, all of which have consistently concluded that as a matter of law, the landscape area is open and obvious, it's not dangerous, and there's no elevated duty to a landowner. And then we get Grimes. And Grimes is the standout, but it is distinguishable. And I understand.
You're into your rebuttal.
Understood, Your Honor.
Seems to me that we might have some questions for Mr. Lee. That you might
course.
like to respond to.
Thank you, Your Honor.
Good afternoon. May it please the court. My name is Brian Lee. I am representing Melissa Allen in this appeal, and I'm gonna jump right into it. I think it's important for us to look at, because a lot of the questions that I think the panel has already asked is we're sort of looking at the standard for what the trial judge was going to do. And this was a situation where the trial judge was asked to first he was asked to grant a motion for summary judgment. He did not do that. And then he was asked to direct a verdict on this particular instance. And as I've cited to in my brief, the directed verdicts motions during trial are supposed to be rarely given. The judge has to evaluate all the facts, all reasonable inferences, the factual inferences, in a light most favorable to the party opposing the motion, which would have been Ms. Allen. And every reasonable inference deduced from the evidence must be indulged in favor of the non-moving party. That's the standard that we have in this case. And so when we then look at the evidence of the case, we have evidence from Ms. Allen and her daughter that the grass in the area appeared dead.
Wait, counsel, can I interrupt you?
I'm sorry, yes, go ahead.
Let me start for where the standard is.
Sure.
If it has to be a well-worn path, your colleague has suggested it has to be a continuous use of that path. Do you agree or disagree?
I disagree because I don't
What's the
believe
level? What's the
the-
legal level? Because here's my problem, and
Sure.
I want to lay it out so you can
Yeah.
do it. If we don't have the way it's currently set up, if landscaping is not dangerous as a matter of law, but there's an exception for a well-worn path, how does that exception to the exception not eat the original exception to begin with?
Sure. And the way I'll answer it is to go back to sort of the general duty that landowners have, and then how this has come about, right? So the general duty, premises liability that landowners have due to the warn, they have to warn of dangerous conditions, due to maintain. They have that is their general common law duty. It's been throughout cases for probably decades upon decades. So then what we have is we have the cases that you talk about, and some of the cases that are cited that say, okay, when we are now faced with a landscaped feature, that is something that is the courts in here have talked about. Normally, that's not something that is made for walking, right? You've seen cases, and some of the cases that have been cited are situations where I think Justice Trey was saying, there's you're a justice now. I was in front of the floor speaker, but
know that somebody's appreciated my brilliance.
Absolutely, Judge. So there are landscape features, meaning barriers, mulch. It's kept up, right? There's one of the cases talked about a tree that was there. It had around it decorative things around it. There are those types of features. And I think inherent within those opinions are a situation where the property owner has done work to that area to make it a landscape feature. That's why they call it a landscape feature. Okay. And so, and because they have done that work there, it is not meant for travel.
Are you
Okay?
are you now disputing that the median in this case was a landscape feature?
I am. I do not believe it is, it falls within what the cases that have been cited are talking about when they're talking about landscaping features.
Did y'all ever argue that below? Or
I
in your
don't
brief?
know. Honestly, Judge, I don't think it was. I think there was more of a distinguishment between the cases. I think as part of the distinguishing cases, when you talk about Grimes, as Judge Nardella said, Grimes takes it away from the landscape feature. There's this body of case law that says landscape features, you don't need to do it because you haven't put that as a walking path. So you don't have duty to people in that type of feature. What Grimes does, and frankly, what the other cases allude to, they talk about is that, okay, but there are situations where even with a quote landscape feature, you could have, and to use the term acquiescence, or just notice by the landlord, by the property owner, that someone's walking through that. When a party starts walking through that, when you have evidence in the record that now all of a sudden it's not the pristine thing that you're looking at, it's something that is quote dead, it's something that looks like people have walked through it. It's those types of notice features that are there. Now that comes out of what the law is, the sort of landscape features are a no-no. Now it becomes a part of the property. So I see it as a situation where you have the property. No one would dispute, I think, that if you have a sidewalk, it's a sidewalk. If you have a parking lot, it doesn't have to be a sidewalk. If you're walking in the parking lot, I don't think anyone's going to say that, well, a parking lot's not a sidewalk, so that's really not a walking path. Yes, it is. It's a walking path. There are various other parts of it. What I think the cases have done over the years is they have said, all right, you have all these walking paths that you're going to have a duty to maintain, but we're going to say that this landscape feature, and it has features to it. It's called a landscape feature. Something that the owner has designated, look, you're not supposed to be in this area because I've done all these things. That they take that out of the general duty to maintain. So then when we go from that to other cases that talk about, okay, well, how do we figure out whether it is something that they're maintaining or something that is truly a landscape feature? And I disagree in some instance, because I don't think that there is a case out there that says if you have a landscape feature which has a well-worn path, the things are dead and everything, it still isn't. They still don't have a duty to maintain. I don't think there's a case out there that says that. What they say in PIO and in other cases is that even if you have a landscape feature, if there is evidence that there's a well-worn footpath, in this case, it's quote dead.
What's the evidence of the well-worn footpath?
The evidence of it is from the.
Let's go piece by piece.
Sure.
Okay.
Absolutely. So I've cited to this, I think in page 13. I might get the page wrong. Starting at page 12. So Miss Ruff, who's Alan's daughter, talks about, she was one that took pictures.
Right. Isn't her testimony looking at the picture? Is her testimony personal testimony of her observation that day when she went and got her mother, or is her testimony her view of the picture in front of the jury while everyone's looking at the exact same picture?
I'm not sure. I think maybe it was both, Judge, because of the way she said it. She said that the grass and the median looked dead to her. So there was a picture that was being shown. But then she also said, as part of her testimony, that it looked like people had been walking through it. Okay. And so as we're looking at the picture, it would have been hard to see that because the pictures aren't.
Is her observation pure opinion?
It could be. I think
if it's pure opinion, does it go to the jury?
It does.
Okay.
Because it's testimony that the evidence builds on one another. So we have hers, her testimony. Even if it was her testimony, I'd still be arguing to her that that goes to the jury.
What's the factual basis that she brought that was personal to her?
I don't know if I
So she
understand.
authenticated the photo. Photo goes into evidence.
Right.
What is she saying that's personal to her as a witness that she's providing an evidentiary basis for the jury to make a determination on, instead of just her opinion that something looks well worn?
Well, she did say that she came back to the area, she saw the area, and she took the pictures of the area. So this wasn't a situation where she never went back to the area, she didn't see it. And she was purely looking at a picture and saying, well, I think the picture shows this. She testified that she went back to the area where her mom was. She saw the area. And so she gave that testimony. So I believe.
So she gives us dead grass, right?
She gives us dead grass.
Does she give us a path, or does she say there's dead grass everywhere?
No, she says that the quote median.
The entire
The
median.
median looked dead to her.
So it's not that there's flourishing grass and then a path of dead grass.
Correct.
It's the median has a grass problem.
That's correct. And even, and although the pictures, as we've kind of both said, and I think the court agrees, are not the best, the pictures bear that out too. This is not, when you look at even the bird's eye view pictures and the pictures that you see even behind cars.
The problem though is how can you tell? Because the irrigation box in those pictures that you're talking about is completely obscured. Whereas unlike the picture that was attached to the depot, I think of Mr. Ryder's client's security director.
Right.
You could see the whole thing. You know, you had the little arrow pointing towards it.
Sure.
The ones that the jury looked at, you couldn't see where
The
your
box.
client fell.
Very true, Judge. But I'm thinking, because we were talking about sort of the general median, right? This wasn't, when you looked at the median, I would say in the pictures, that this wasn't something where you saw grass that was this big, look very manicured, kept up, you know, that we would typically see.
Right, but
you know.
lots of things can cause dead grass, right? Shade from the
Sure,
tree,
it does.
shade from the building, failure to fertilize, winter.
Right.
Lots of things can cause dead grass. So dead grass alone is enough to go to a jury on the path being well worn.
I don't think it is, Judge. It could be. Well, let me say it this way. I think it could be in the sense that the fact that grass is dead, and this is me looking at other opinions, is that it's not maintained as that area. To have a quote, to have a landscape feature that, yeah, I kind of akin to it to your house. Right? I mean, if I have a landscape feature in my house and I've got bushes and I've got flowers and I've got it, that is a maintained thing. You know, and so if all of a sudden the flowers and everything I had there was just purely dead, there was nothing in it, does it become a landscape feature anymore? I think that.
But it also doesn't become a footpath, right?
Correct.
And so let's just take, I'd be troubled if you were switching your position on what this was, just to let you know where I am with this. So it doesn't seem to me that's what you argued below.
No.
But so if we just assume that's the lay of the land, that this is a landscape feature, at a minimum, this is a landscaped area where people are not meant to walk, I would think, at least originally. So I think what Judge Nardella is asking, which is my question too, is, well, if we just have dead grass, maybe because we're in Florida, maybe because the other reasons that she outlined,
Right.
why does that make it significant? I mean, when I look at PIO, it talks about continuous and obvious use as a pedestrian shortcut, right? Or it talks about a path. It's a footpath. I'm not sure that an area that has dead grass makes it a footpath.
I understand what you're asking. The testimony below, it didn't just include Miss Rowe. It included Miss Allen herself, and Miss Allen said that the grass in the median looked dead as if other people had been walking through it. All right. So she says very specifically about that. Now, you do have some tested from Elizabeth Anderson, who's the security coordinator for Caribbean, who said she testified that of course, it was possible for guests to walk across the grassy median areas, and she didn't fault Miss Allen for walking in those areas. Okay. And so this wasn't a situation where everyone at Caribbean says, no, guests are never supposed to walk through there.
I mean, isn't that just polite? Isn't that just her being polite?
It could be, Judge, but again, you know, I get back to what I began with. When we have this evidence of it's dead. That the evidence from Miss Allen that it's dead because it looks like there's people been walking through it. When you have evidence from the daughter that says it looks like people been walking through it, it is for the trial court to look at that evidence, and everything goes favorable to Miss Allen. And when we look at the cases that have been cited, Grimes is the closest one.
But if all I have is it looks like people have been walking through it, the factual basis that's given to the jury for that opinion is only dead grass, right?
I
They
think
don't
it's-
say anything else. They don't say, well,
I think
it
it's
felt
both.
differently. It was hard here. It was soft here. There's nothing else, right?
I think it's both. I think it's that what Grimes says is that I think they call it a footpath, a well-worn footpath at some points, and a footpath that looks like it has been by people walking through it. That's what Grimes talks about. The way you get to that, I think, could be many different things. In this case, we have that the grass was dead and it looked like people were walking through it. In another case, it could be something totally different. It could be that, well, I looked at the median area and I saw footprints of people who had been walking there the whole time. It could be that. There could be other evidence. It doesn't have to be one piece of evidence or this piece of evidence. It's evidence that shows, or evidence that there is a footpath there that pedestrians have used.
Do we have that? Do we have any evidence of a footpath that pedestrians have used? Because I grant you, I think what you're saying is consistent with the case law. And it sounds like we have an area with dead grass where it looked like someone could have walked there before, right? By the daughter's testimony.
People had walked.
So where's that line?
I don't.
100
Sure.
people?
No, and I don't, and I don't think there is a line that a trial judge can make in that. And here's why. It's very akin, and obviously this court knows the directed verdict standard is very similar to summary judgment standard. Probably the same thing. And when we look at testimony, like summary judgment, like directed verdict, the trial court is not able to weigh evidence. He's not able to look at evidence and say, well, I know I have evidence over here, or I know I have evidence over here, but I think this evidence is better evidence from this side, and therefore I'm going to take that away from the jury. The law doesn't allow the trial judge to do that. And so the trial judge found that there was evidence, at least some evidence, that put this within the realm of what Grimes was talking about. And frankly, that none of the other cases say Grimes is just wrong. They say, well, we don't have the same evidence as Grimes because there's no evidence of a footpath here, or we don't have evidence of this, we don't have evidence of that. That's how cases distinguish it. So there is no case that says that just Grimes is just wrong on its reasoning.
What about how Grimes says, if the parties responsible for maintaining a landscape feature allow the particular landscaped area to become a regularly used footpath? I think this goes to what opposing counsel called acquiescence.
Mhm.
But if they say allowed it to become, and then in that case, we've got the trash can that's distinguishable from ours. Do we have any evidence that they have just allowed this to go on, that there is any sort of acquiescence?
I think that the fact, as Grimes has said, allowing a landscaped area to become a footpath is acquiescence, if you're looking at it in that lens. I don't think that acquiescence by a owner is a requirement to do that, because in Grimes, they were talking, and in other cases, they were talking about that as being evidence of constructive notice, which obviously is different than actual notice. What the appellant is saying is, well, there has to be actual notice, not just actual notice. There has to be actual notice, and we did something else to make it even more the way it was. That is, none of that is in any of the cases that you will review here. What you will review is Grimes saying that if they allow that to become a footpath, and I guess inherent is that, and they just don't do anything about it, that is evidence of constructive notice. Now, Grimes, of course, was in a situation where we're looking at judgments and things of that sort, but it's the same situation as a directed verdict. And the trial court who's there, he's heard the evidence. Obviously, this court has de novo standard, right, to look at that evidence. but this is not a case where there is just void of evidence of what Grimes calls a regularly used footpath. I'm sorry, go ahead.
No, no problem. Before we let you go, I had a quick question about the third issue.
Sure.
In your answer brief, you cite a series of cases that were all issued before the Supreme Court's holding on supremacy of the text. And you refer to the 50 CA case as an outlier that we shouldn't attach on to. Sure. I'm wondering if you could just help me with the notion that the 50 CA case seems to be the only case in the body of case law that applies the supremacy of the text principle.
Sure.
Are you aware of any other case that analyzes the statute differently? Can you help me read the statute differently other than a directive to say that these shall be set off subject to a subrogation exception that clearly doesn't apply in this case?
Sure. So I do not know of any other case that has made the same ruling or the same analysis as the Fifth District case. The cases obviously before it have been, they've come from the premise that just the set off issue itself is an affirmative defense. It isn't in this case. And because of that, case law, Florida rules say that the defendant has the burden of proof on that. They have to show that they are entitled to a set off. And so I think what the cases have said is that, you look at the statute and it says it shall be set off, right, from that, but it doesn't talk about the procedure for doing that. So it says that you do have set offs, and you have set off in certain situations, but the procedural part.
I think what I'm struggling in terms of that answer is that the statute does say when you don't do it. It seems to me, and please correct me if I'm wrong, it seems to me that you're advocating for a distinct exception other than what is contained in the statute. So shall set it off, except for subrogation, and except for when we can't tell.
Right. And it's that last part,
right,
that is, I think, part of why there's that burden of proof.
But give me your best statutory argument as to why we should accept that construction.
Because if that wasn't when you look at the statute as a whole, it is under the premise that has been shown. Okay. It's not a statute that just says, if you have these and you have this, then it's going to automatically be taken out. It has to still be shown by the defense. And so part of that, if it's not shown or if it's shown, is the burden of proof they have. They have to point out to the court under the statute, here are the bills that were given by the jury that line up with the health, which means that now there's a subrogation or reimbursement, right? Which means that you can now set those off. It doesn't abrogate, the statute says it at the end, and it also doesn't abrogate the fact that the defendant has the ability to do that.
Do you agree? And I guess I'll ask this in a slightly more pointed way.
Sure.
Do you think that you could sell your trial court colleagues on the notion of what you would need to do if that's right? In other words, you would probably need to itemize every invoice, right?
Yeah.
Is that what you're advocating for?
Well, and
it's what
am I advocating for? No, of course not. But each of us, plaintiff and defendant, we have our burdens of proof. Mm-hmm. Sometimes our burden of proof is not easy, but that doesn't mean there's still not the burden of proof. I would see your argument more, Your Honor, if a defendant says, "Look, I have this burden of proof as my set-off defense, and therefore I want to have an itemized verdict for him." And the judge then says, "You know what? We're not doing that because that's just too unwilling. I'm just not doing it." Mm-hmm. If that defendant were then to come up to you and say, "Look, judge, stop me from a burden of proof," we might have an argument, but we don't have that here.
I'll let you go on a little bit longer.
It's my pleasure.
And you guys are still asking questions about the first issue. Do you have any more that you wish to ask Mr. Lee?
Okay.
You good?
Yeah, thank you.
Okay. Well, thank you, Your Honors, and I would ask that you affirm the judgment. Thank you.
Mr. Ryder. Thank you. Well, I'll start by noting that we have never heard the notion that this wasn't a landscaping feature. This is not something that was intended to be a path, a footpath. It's a landscaping feature.
Does he have an appellate burden?
Well, I think it has to be at least raised in the brief, Your Honor. So yes, there is an appellate burden to at least advance that as an argument.
As an appellee?
Sure. I mean, in other words, as an appellee still has to put in their brief a specific argument that and what I'm saying is, I don't believe even in the brief, was there an argument that this shouldn't even be considered a landscape feature?
Is there a difference between a landscape feature and a median?
I don't know that that's something that's borne out in this record, Your Honor, but
If you could just answer my question, because in looking back at the testimony from both the plaintiff and her daughter, I just noted that it's not referred to as landscaping, it's referred to as a median.
Understood, but
Is there a difference between landscaping and a median?
not in this context, Your Honor. Here's what I mean. I'll answer the question,
Thanks.
I guess it's well, one would say horticultural kind of question, but no, it's a median can be a landscape feature, right? So to me, a median is a dividing line between, for example, sidewalk and a piece of property. This median, what we call it a median, was a landscape feature because it had grass, it had plants, it had dirt. It was not a median that was a nature of a sidewalk. It wasn't a median that one might see, for example, in a public street where there's a median that actually you could step onto. And I think that's a median also, but it's a different kind of median. So I use the word median, but it's really, I believe that this is unequivocally a landscape feature. And I don't think anyone has ever challenged that description of it or definitionally.
What, if anything, in terms of how you are asking us to look at this, this particular feature, what weight, if any, do we give to the fact that the plaintiff says, hey, I followed 12 people across it. You know, they naturally went across this particular path.
Well, I'll start by saying that that's not precisely, I don't believe the testimony here. I don't believe it's exactly like that, Your Honor. What I mean by that is the record reflects that her own daughter, I think it was her daughter and her boyfriend, took the sidewalk. So let me start by saying that others in the group utilized the sidewalk. And it was the mother who decided, the plaintiff, who elected to go over this landscape area.
I'm just looking at 973. Everyone was taking the exact same path. Answer, yes, sir.
Yes, and then on page, I don't have it right in front of me, but there's the language where the daughter mentions that she went on the path with, I think it was her boyfriend following another individual, and couldn't explain why her mother used that path. She was asked, do you know why your mother elected to go?
No, certainly I get that there's
Right.
competing
There were-
testimony about the daughter having to come back and see where her mother had fallen.
I guess the point I want to make is that I don't think the evidence suggests, other than that comment, I don't think it was a situation where, like, for example, you said 12 people ahead of her, or I don't remember anything that specific.
Yeah, I'm
Your
just
Honor.
reading it from 973.
Or she said she followed other people. But if I may go back to it, and I'm Judge Brownlee, you were about to ask a question. I don't want to.
Did you finish your question? Chief?
Yeah, I'm good.
Counsel, what are we, if we are an error correcting court, which we are, what are we to do with the fact that we have the evidence that Chief Judge Traver just cited? We've got the security guard, we have the daughter, we at least have evidence there that people have walked on this area. And let's just, your best day, it's a landscape feature, right? So let's just call it that. And say that we have evidence in the record that people have walked on that. The grass isn't great. We've all seen what it looks like, at least from that picture, what we can make of it. And hang on, counsel, I've got a directed verdict standard, and I have the trial judge looking at that, looking at the case law and saying, yeah, it's got to go to the jury. I don't think it's strong. I mean, I don't know what he was thinking, but maybe it's strong, maybe it's not. Does he have enough there to send it to the jury on directed verdict?
Okay, so let me start with the concept of this being an error correcting court, and just suggest that on a de novo standard of review, when examining the evidence, even construed in light most favorable to the non-moving party, I think it's different because this is a de novo standard. There's no presumption of correctness. There's no deference to the trial court. So this is a little bit different in the sense that on this issue, at least, I'm not asking this court to reevaluate whether the judge made a correct discretionary decision. So as it relates to this issue, it's de novo, number one. Number two, the question of, is there a line? And this came up with Mr. Lee. Is there a line? And the suggested that I wrote it, he said that There is no line. That was what he said, and that's strict liability. And it's well established. This is not a strict liability issue. To suggest that there's no line, at which point this becomes a distinction between a landscape area that the cases have continuously said is it open and obvious and not dangerous as a matter of law, to a well-worn footpath, there has to be a distinction.
But then how's the trial judge supposed to know what that line is?
Here's how. It goes to the heart of this notion that whether it's the plaintiff who perceived it or 10 or 20 people who did it, that in and of itself does not translate into the duty onto the landowner, because it's not what the plaintiff perceived, it's what the landowner knew. And it goes back to this issue. I did refer to it as acquiescence, but it really is a matter of constructive notice. And you'll recall, you asked me that when I was up here before, and you said, does it have to be actual notice? And I said, no, it can be constructive notice. Constructive notice in Grimes and in all of these other cases means that it had been utilized as an ongoing and continuous path. Not that some people used it, not that sometimes people traverse it, but an ongoing and continuous use. That's constructive notice, and that's acquiescence too. But at Grimes, again, I use this because it's such a clear distinction, is the landowner put a garbage can because they knew that people were using it as an ongoing continuous path, and that it wasn't even grass, it was a dirt path. That is not this case. To me, I would submit that when you look at, and I won't go through all the cases.
What's your client, in terms of evidence adduced by your client? And I recognize that this might not be an entirely apposite question, but it might help with, I think, with what Judge Brownlee's asking, which is where does the trial judge draw the line?
Okay.
I recognize that you didn't try this case. Where in the record, what did your client do to reduce any information or evidence that this was not a well-worn path, or that they did not know about it?
So I can say, number one, we adduced evidence through testimony that there was no signs suggesting that this was an area to be used. In other words, there was no indication that there was, I'll use the term acquiescence, but there was nothing that suggested that the landowner invited people to use this path. Okay, there was a sidewalk abutting this path, this landscape area. There was a sidewalk there, which to me suggests that's evidence that the landowner intended or knew that there was an area for people to walk so that they didn't have to use this. And the Anderson testimony, this was the only testimony from our side that went to the issue of what we knew. And what she testified, this is at pages 708 of the transcript. She testified that some people do walk over it, even though there's a sidewalk. And you agree that based on that testimony, you've seen guests walk across the landscaped area. By the way, the question by the counsel was a quote landscaped area prior to this incident involving my client. Answer, well, I did say it's possible. Everything is possible. So we acknowledge that it had happened over this landscaped area, as it was even referred to by counsel in his questioning of our client at the trial. But at the end of the day, knowledge that people do it from time to time doesn't mean that it has become an ongoing continuous use that transforms or elevates this landscape area into a path made for walking. Finally, Your Honor, you raised the set off. I'll rest on our brief unless you have any questions. To me,
Yeah, I
that's
got one more
clear.
question.
Yes.
I'm
Oh, sure.
bad habit of asking questions after time has passed. I'll apologize to my colleagues. You, I think it was from Judge Nardella. You answered her question, as you should have, candidly, when she asked about, this wasn't you, it was Judge Brown, my bad, about the common law basis for the Grimes exception. And you basically said responsibly, there is no common law exception for the Grimes. I went back and looked at your initial brief. I read your initial brief to basically not advance that argument, to basically say, hey, look, Grimes is out there. We're going to be able to distinguish it. And we're looking at this constellation of landscaping exception cases and the exception to the exception. Do you at any point in your initial brief, and if so, can you point me where are we trying, are you asking us to revisit the entire concept?
I did not ask this court to revisit the entire concept of whether or not an ongoing continuous path constitutes an exception to this principle. I didn't go that route because I don't think we need to respectfully in order for this court to reverse. Based on the facts of this case, based on the overwhelming other case law that's out there that are factually analogous, and based on the incredible distinctions in the Grimes case. So I elected not to confront Grimes as being inaccurate. I just distinguish it.
Fair enough. Thank you so much for the candid answer.
Sure.
Does the panel have any more questions? Okay,
Thank you. And of course, we ask that the court reverse and remand with directions to enter a judgment for the appellant or alternatively a new trial based on the arguments raised in the brief. Thank you.
Thank you both for the presentation. It's an interesting case and we will take it under advisement.